The University Grants Commission's new regulations on caste-based discrimination in higher education, notified in January 2026, aim to create campuses free from discrimination and ensure equal treatment of all students. These rules came after high-profile cases like Rohit Vemula in 2016 and Payal Tadvi in 2019, whose deaths highlighted ongoing caste-based harassment in universities. The Supreme Court had directed the UGC to strengthen anti-discrimination rules, and these new regulations include mechanisms like equity centers, committees, and coordinators to monitor campuses and address complaints within strict timelines. On the surface, the rules are designed to protect historically marginalized groups, giving them a safe environment to report discrimination. Every college must establish an equity center and a committee that meets regularly to review complaints. The coordinator can even involve police and convene meetings within 24 hours if issues arise, with reports submitted to the institution head. If action isn't taken within 7 days, the institution faces penalties, including potential funding cuts. The intent is clear: ensure protection and accountability. However, the regulations also create legal and procedural questions that cannot be ignored. Firstly, protection and grievance mechanisms apply only to SC, ST, and OBC students. General category students, who may also face caste-based discrimination, are excluded from these safeguards. Secondly, the previous false complaint safeguard, which protected students from misuse of the system, has been removed. This raises concerns that complaints, true or false, can be filed without consequences, creating fear among general category students that they may be unfairly penalized. Thirdly, the rules impose intense administrative pressure on institutions. College heads, under the threat of losing funding or recognition, may act hastily, sometimes prioritizing procedural compliance over fair investigation, potentially punishing innocent students while trying to avoid penalties themselves. These concerns have sparked debate. Critics argue that the regulations, though intended to combat discrimination, may unintentionally create reverse discrimination and undermine the principle of equality before the law, guaranteed under Articles 14 and 15 of the Constitution. While Articles 14 and 15 protect against caste-based bias, they also ensure equal protection for all citizens. By defining caste discrimination in a group-specific manner, the rules may exclude some victims, creating a hierarchy of victimhood and weakening legal fairness. Even UGC's own data shows that complaints from 2019 to 20 to 23 to 24 increased, but as a percentage of total students in higher education, these are extremely small, essentially 0.003%. Should such a marginal statistical increase justify a legal framework that can penalize innocent students and create widespread fear? The broader question is not whether caste discrimination exists. Clearly it does. But whether a legal framework designed to fight discrimination can be selective without creating new injustices. Equity mechanisms are necessary for historically marginalized groups, but these cannot come at the cost of procedural fairness for others. Fear of punishment, lack of checks on false complaints, and institutional pressure could distort the very justice these regulations aim to achieve. To balance protection and fairness, several measures could be considered. First, preliminary inquiries should verify complaints before any major action is taken. Second, an independent review panel, including external experts or retired judges, could assess serious complaints to ensure impartiality. Third, committee structures should be neutral, insulated from political or institutional pressure, and decisions should be based solely on evidence. Only with these checks can regulators protect vulnerable students without creating fear or unjust consequences for others. In short, the UGC's regulations highlight a tension. Safeguarding marginalized students is essential, but the mechanisms must also uphold universal legal protection, maintain due process, and prevent misuse. True equality is not achieved by protecting some while leaving others exposed. Law and justice must address discrimination, not create new vulnerabilities. If implemented with balance, the regulations can promote safe, inclusive campuses. Without balance, they risk replacing old injustices with procedural anxiety, undermining trust in higher education and the very principle of equal treatment.